Thank you. Can we start?
Thank you. This is in the High Court of South Africa, Gauteng Division, Pretoria. Today is the 18th of September 2023. This is an application for leave to appeal before the Honorable Madam Justice Collis J, before the Honorable Justice Malindi J, before the Honorable Justice Mota J. This is case number 32323 of 2022. In the matter between the Minister of Home Affairs, the first applicant, the Director General of the Department of Home Affairs, second applicant, All Truck Drivers Forum and Allied South Africa, the third applicant, and Helen Suzman Foundation, the first respondent, and Consortium for Refugees and Migrants in South Africa, the second respondent. May it please the court?
Yes, thank you. Just confirm your names for the record.
As the court pleases, my lady, and the two justices. My name is William Mokari. I appear with my colleagues who are sitting with me here, Mr. George Addis and Mr. Mokatla, for the applicants, which is the Minister and the DG.
Thank you, Mr. Mokari. The third applicant.
My lady and justices, firstly, I would like to apologize for the late connection. We had a problem with the information of what time, and then the second issue was the technical issues, but we were initially told that it was 10 o'clock, so apologies. My name is Mujapelo MM. I appear with my learned colleague, Mtsweni. We are together in the same room.
All right, thank you, Mr. Mojapelo. Then the first and second, well, first respondent.
Good morning, Malay Canberg, and I appear with Mr. McConaughey, Mr. Gekwa, and Ms. Kritzinger for the first respondent.
Thank you, Ms. Steinberg. The second respondent.
May it please the court, I appear on behalf of the second respondent, Kwamsa, in this matter.
Thank you, Mr. Simmons. All right, you would be aware that I'd sent out a communication last week around the time allocation for the hearing of this leave to appeal. We've now already 15 minutes behind, so all of you are requested then to try and make up the time. And the reason for that is simply that we have other responsibilities to attend to after lunchtime. So can I ask you to try and make up the time that we've lost now as far as possible? All right. You can accept that we've read your heads of arguments, and thank you for preparing those heads. So if you wish, you can just simply succinctly take us through the salient points that you want the court to focus on in your respective applications, and also the opposition to those applications. All right. If you are not addressing the court on the platform, you're welcome to switch off your microphone. Obviously, your microphones must be off, but also your video feed, and only switch it on once you are addressing the court. The three justices, obviously, we will keep our microphone and our video feeds on. Thank you, Mr. Mokari.
Thank you, my lady. My lady, I am going to speak softly. I hope that my sound system is very good, and even if I speak softly, you'll still be able to hear me, because I'm missing my voice because of flu. But I'll keep on drinking warm water as I go along.
With some lemon, I hear it's very good. So warm water with some lemon.
Thank you, my lady.
Thank you, Mr. Mokari. We can hear you clearly.
Thank you very much. My lady, as you have already pointed out, this is the leave to appeal, which has been filed against the judgment and the order that this court has delivered in this matter. I'm alive to the time allocation that the court has given to each of us. I promise that I will stick to the time frames as given to us by the court. I'm also going to simply highlight the salient points which are relevant to the leave to appeal in respect of the 3 grounds of review which the court upheld in favor of the Helen Suzman Foundation or in favor of the respondent, in order to demonstrate that on the test postulated in section 17.1 of Superior Courts Act, another court would come to a different conclusion because of the requirement that where there are prospect of success on appeal, the court should grant leave so that the appeal court can consider the matter. The orders that the court made appear at page 62, that is 00062. It is 2 types of orders. One is the main order of review and setting aside, which was granted in terms of the powers that the court has, depending on whether the court grants it under the Constitution, which is section 172(1), then it will be an order under that section to declare a conduct which is invalid and unlawful to be so, and to review and set it aside. And it will also depend whether the court is doing so under PAJA, and on that occasion, the court will also use a different legislative regime in respect of the appropriate remedy. If it does so under PAJA, it will be under section 8, and if it is the review under legality, that is section 1C of the Constitution, it will be under section 172 of the Constitution. So we are appealing against the order in paragraph 147 as a whole, including the consequential orders which were made by the court in paragraph 147.4. In this paragraph, the court exercising its powers, as it said, under section 8 of PAJA, it says it granted an interim relief, and it also did so, as it says, under section 172(1)(b). But I'll come to why we say that the court could not competently do that under these 2 separate regimes when I address the appropriate remedy. But first, I'd like to point out those aspects of the judgment right at the beginning, which we agree with. Paragraph 1 of the judgment at page 0002, the court says that this application concerns matters both of great importance and of striking ordinariness. My emphasis is on the great importance. We agree with the court that it is a matter of great importance, and this is also emphasized by the court in paragraph 2, the last part of it, 0003. This is thus a case of considerable public significance, not only to all ZEP holders, but to the Department of Home Affairs as well. We agree with this because this is not only a matter of great importance and of considerable public significance, but is a matter that raises huge constitutional implications, which revolve around issues of asylum, immigration, the refugee, economic, political, and socio-economic considerations which any country has to take into account when dealing with how it deals with the acceptance of foreigners in its own or within its own borders. So it is a matter, of course, of huge public importance. The history has been narrated by the court as to where this Zimbabwean dispensation originated. What we wish to also highlight, which the court was also alive to, is paragraph 3 and 4. In 3, the court said, while the minister has recently extended the grace period by a further 6 months until 30 June 2023, his decision to end the ZEP program remains unchanged. In paragraph 4, the court says, in terms of the said program, and for approximately the past 14 years, qualifying Zimbabwe nationals have been granted permission by the Minister for Home Affairs to live, work, and study in South Africa. And in paragraph 5, it says, as a consequence of being granted this permit, ZEP holders have established lives, families, and careers in South Africa. The termination of this program has placed all this in jeopardy, which decision holds profound consequences for ZEP holders. This much is common cause between the parties. So the court was alive to the fact that the Zimbabwean dispensation had its origin on the policy that was adopted by government through, of course, the executive responsible for Home Affairs, which is the minister, as way back as 2009, as a policy decision of government that due to the influx of Zimbabweans into South Africa, as a result of instability in their country arising from socio-political and economic circumstances, and the strain that influx was causing on the immigration regime of South Africa, the inability to cope with asylum seeker programs in place. Government took a decision that as a matter of its policy, it will grant the Zimbabweans some form of a dispensation which will regularize their illegal stay in South Africa in order to avoid putting strain on people coming in and deported back and coming back, deported back, putting strain on government coffers. So that was the government policy at the time in 2009. And that has been flagged actually by the court in the sequence from page 00010, paragraph 21 onwards, where it deals with the history of the ZEP. We know that it was changed in terms of how it was called in different times. Initially, it was called the DZP, and of course, then we know what that entailed. It was called Dispensation of Zimbabwean Project, and later in 2014, it was then called something different and replaced with Zimbabwean Special Permits, and in 2017, it was again called the ZEP, which is Zimbabwean Exemption Program. But all the three of them remained with one focal point, which was to temporarily ensure that Zimbabweans remain in South Africa until such time that government, and here when I say government, I use it in the context of the responsible executive for Home Affairs, because he's the one who is empowered as the executive to take such decision or policy decision. So when I say government, I'm referring in that context until government is satisfied that it can terminate this program. So we are aware that there has been a debate when the matter was argued initially as to whether there was a termination of this dispensation by the minister, or whether it was something different. But after the court has analyzed the facts, especially at objective level, it concluded that indeed there was a termination of this dispensation. And I'd like to place on record that we do not take issue with that conclusion, that indeed there was a termination of this dispensation by the minister, and what the minister continued to do was to provide grace periods in terms of periodic short extensions for those permits, as it has been enunciated in the judgment. But the decision, of course, was taken that the program is terminated, and what was left was how to ensure an orderly implementation of that decision, taking into account the material conditions on the ground, that if it was feasible at a particular time, it could be implemented right away. If not, the minister from time to time takes a decision to provide those grace periods to extend then those permits. So the issue really then before court, as the court correctly pointed out, was whether the termination of the Zimbabwean dispensation of the exemption program that was given to the Zimbabwean national accorded with the constitutional prescripts, and whether it was done in a manner that is permitted by law. And permitted by law here, it will be law of general application in respect of the acceptance of foreigners in the country, them being granted exemption, and at what point that exemption may be taken away. So this one, it was a special dispensation which was initiated temporarily to deal with a particular situation which was prevalent in 2009 and continued so until when the minister decided that those conditions were no longer prevalent, and therefore there is no more legitimate or governmental legitimate purpose to allow this dispensation to continue. Hence, it was terminated. So that would have brought the court to the determination of whether that termination falls under Administrative Act or whether it is an executive decision or one that is more closely linked to policy making, or whether it is policy laden. So we submit that on a proper scrutiny of this decision, looking at how initially it was taken in 2009 and the purpose it sought to serve, and its termination, it is one that is more akin to a policy-laden decision than administrative decision. And that becomes material because the factors that the court looks at in order to determine whether an act performed is administrative or executive is not an easy one. In certain areas, it's quite a gray area, and that is why the Constitutional Court attempted to assist the courts, and I would say lower courts like high courts, when they are confronted with such matters, whether to determine the nature of the decision or act, to look at the factors that the Constitutional Court has set out in Mutau versus Minister of Defense, and paragraph 36, 37 to 14 of the judgment are quite instructive on what the court must look at. So we say that when one looks at the features, that this was a policy-laden decision, and therefore the only way the court, the only way the minister's decision could be attacked is whether the minister's decision is rational. Rationality is a low threshold type of review because it is more linked to the principle of deference, where the courts are loath to interfere with executive decision making, particularly when it is more linked to policy. Because where policy comes into picture, there are many complex issues which are interlinked with other features such as economy, security, then politics, and so on. So the courts are often reluctant to enter into that terrain because it does not regard itself as a specialized forum to make such determination. So we submit that what the court ought to focus on will have been to determine whether the decision to terminate was a rational decision or not. And in order to determine whether a decision is rational, the court should be guided by what the Constitutional Court has said in the President of the Republic versus the Democratic Alliance versus the President of the Republic of South Africa, what is referred to as a Simelane decision, the reasoning by Yakub J, as he then was. So rationality, one must consider then or a close examination of the origin of the decision and the end of it. So one has to look at what was the purpose of the initial decision in 2009, and one must look at the end of it, whether it achieved what it sought to achieve. If the court finds that the initial decision, which was to give reprieve at a temporary basis for Zimbabweans because of the situation in the country, then the court cannot interfere with the decision to terminate if the executive concludes that those conditions are no longer prevalent, and therefore this dispensation must come to an end. So you find that there is that link between the origin and the end. And if that link then exists, the court should be loath to interfere with that conclusion, even if the court were of the view that it would have dealt with the matter differently. So we rely then on the Simelane judgment for that purpose, and we say that the court ought to have exercised or embark on that exercise of rationality. What the court did here was to embark on a procedural rationality inquiry, but it intertwined it with procedural fairness. And the two are quite distinct because the one, which is procedural rationality, rests in the Constitution, which is 1C. That is the procedure that one embarks upon to arrive at the decision must be linked to the purpose of that decision itself. Whereas procedural fairness rests in PAJA, where one simply looks at whether Audi has been granted to the affected person. So the two serve completely different purposes, and the test is completely different but the court has conflated the two as if procedural rationality is the same as procedural unfairness, whereas then they belong to the two separate regimes of attack of decisions by public officials or organs of state. So then we say that the appeal court could find that it was inappropriate for the court to have dealt with the termination decision as part of administrative act when it ought to have dealt with as a policy-laden decision which required deference, and the minister then to be given that space as long as he was able to justify the reason why the decision to terminate was arrived at. So that brings me to flagging the grounds of review under PAJA to the extent that the court has determined that PAJA applies, and we say that PAJA did not find application because of the nature of the decision based on Mutau, but to the extent that the court has found that the decision affected members of the ZEP adversely, and therefore it was incumbent upon the minister to have consulted with them. That again, it goes to whether section 3 and 4 of PAJA would apply, and if it applies, how it has to be implemented. We are alive of the judgments which require a prior consultation and judgments which permit post-consultation, as long as the circumstances of the case are of such a nature that the decision maker will still remain open-minded and persuaded by the submissions that have been made post a decision. So we submit that in this context, one will find that although the minister did not embark on a prior consultation with the ZEP members, the minister did engage with them and receive representations post the decision so that he can still remain with an open mind in order to still make a decision if persuaded otherwise. But the court has found that the minister has already closed his mind because of the utterances that have been made preceding or even after the opportunity that has been given by the minister to the ZEP members, because the minister said the decision is final, and so the minister has closed up. But we submit that the type of representations that were made and which were received were of such a nature that did not tilt the scale on the state of mind that the minister had already pronounced himself on. But that again goes to procedural fairness. And the other point that the court raised related to the impact on the Zimbabwean exemption permit holders, that the minister did not take into account the impact that will have because of the duration that members of the ZEP have been in the country. They've been in the country for over 14 years. If one takes from 2009, they've had children and they've had families, jobs, and other forms of relationships that they have established in the country, and that the representations by the DG which he made to the minister did not take those factors into account. So those factors, of course, are factors which will be inherent in any decision making, And the minister dealt with that in his affidavit. When I say the minister, I'm referring to the affidavit deposed by the DG. I'll come to the criticism that was leveled on the absence of the confirmatory affidavit by the minister, but the affidavit was, of course, filed on behalf of the minister, which dealt with those aspects of the impact that the decision will have on the ZEP members, and of course the court has said that it was common cause that such decision, of course, will affect the ZEP members. It will affect even the children, but of course, then in situations where the interest of the children come into play, the court then always assume an upper responsibility, including providing the necessary directive as to the necessary information that must be placed before it in order to be satisfied, including the appointment of the services of family advocates to determine the impact that will have, and also ensuring that the interests of the children are objectively taken care of, not on a subjective basis. So the court always assumed that inherent power as a super guardian, upper guardian of the children, to ensure that the interests of the children are catered for. What is always clear is that when the dispensation commenced in 2009, and it continued for a period of 14 years, it was almost inextricable that the Zimbabwean ZEP members will assume a certain obligations and duties within the country, including having employment and also conducting their education and having children. And that is what always has been foreseen, but that could not have created an impression that the dispensation was created to be permanent. But it still remained a temporary measure in circumstances where, when the time comes, then the Zimbabweans will have to return to their country, when one can say that their country is now safe, the democratic processes have returned, and the economy of the country is recovering, and they should be able to return to their country, because their legalization in the country was on a temporary basis and not on a permanent basis. So that is how then the court then will deal with situations pertaining to the children and balancing then those conflicting rights. The court has dealt with the issue of dignity, for example, but dignity, of course, then entails the balancing of rights in the context of whether the dignity that is alleged to be impugned is one that cannot be ameliorated by other measures that government can put in place in ensuring that the return of Zimbabweans is done in a manner that is orderly and a manner that does not fragment families. So that can always be ameliorated with the implementation of the program itself, than to close up and say that as long as it's going to affect their dignity, because then their children are already accustomed to staying in South Africa. The upshot of it is to say that no decision can be made by the minister which will result in Zimbabweans having to return to their country, because then one will argue that they've already cemented their lives in South Africa to an extent that to uproot them from South Africa is to disrupt their families, and therefore unconstitutional and infringing their dignity. And that is why then we have taken issue with the summation that the Zimbabweans have established families and everything in the country. So which suggests that there will be no decision that can be taken which will ensure that they are ultimately returning back to their country. So the dignity is an important fundamental right which is entrenched in our constitution, but it is one that requires a balancing exercise in the context of other factors that have to be taken into account when a decision of this nature is to be taken. And that could have always been ameliorated by the aspects that I've already highlighted which the court will have actually taken into account and even ensured that it issues the necessary directives to that effect. So that really is the submission which is intertwined with the absence of the consideration by the minister on the impact, together with the limitation of rights, clause section 36 of the Constitution, which the court has found that the minister has failed to provide the necessary justification. But we've provided in our heads of arguments case law which deals with the context within which section 36 is to be applied and how justification is to be employed in the context of the limitation of rights. For instance, there was an issue about whether the minister has satisfied the court regarding the allegation pertaining to budgetary constraints. The court concluded that the minister did not go far enough to demonstrate that there were indeed budgetary constraints and did not meet the test in Rail Commuter Action Group matter. But that has been dealt with in detail in the further affidavit that was filed on behalf of the minister. That budgetary constraints has always been the issue, and that has never been a question. The department requested 146 million rands, and the Treasury only made available 15 million rands. So it was clear that the budget was not available to cater for the ZEP program in such a manner that it will enable the government to continue with this program in perpetuity. Hence, then, it was necessary that a policy decision be taken on how to orderly ensure that the Zimbabweans return back to their country. So we submitted that the criticism on the absence of evidence or information regarding budgetary constraint is one that was unjustified placed on the doorstep of the minister. And of course, and the court has dealt with it in the context of the absence of the confirmatory affidavit from the minister. We know that affidavits in motion proceedings serve as both pleadings and evidence. So evidence is presented by whoever is in a position to give evidence which will assist the court. In this case, the person... Yes, Justice Malin.
Before you deal with the standing or status of the answering affidavit, in regard to consideration of the impact that the termination had on the ZEP holders, and in considering whether the conditions that brought about the institution in 2009 and whether it's ready for termination, is the court allowed to inquire into the adequacy of both categories that you've addressed the court on so far?
Yes, I am of the view that the court is permitted to inquire into the adequacy of the plan that is put in place for the orderly implementation of the decision itself. So that we make a distinction between the decision itself and its implementation. But the court, of course, then can always inquire. And if the court is not satisfied that the proper plan is put in place for the implementation, it is always open to the court under Section 172 of the Constitution to even put structural measures or structural interdict, that is, for lack of a better word. It's not really an interdict, but an injunction which will direct then the executive on providing it with a plan that it will implement in order to ensure that the implementation does not affect the fundamental rights which have been spoken about. So then that is always open to the court.
Thank you very much.
All right. Mr. Makari, you only have about another 10 minutes left. So I take it you were about to, you were going to deal with now the affidavit or the lack of the affidavit by the minister.
Yes. So I'm dealing
I
with.
think in your heads you still have the substitution. You say the court ordered gave a substitution order, and then you will have to deal with costs. But bear in mind that you only have another 10 minutes.
Yes. No, I'm able to cover all those.
Okay.
That in that time.
Thank you.
Yes. So now on the absence of yes, I've said that in motion proceedings, affidavits serve two purposes. So there are pleadings at the same time. They constitute evidence, and evidence is always given by the person who is able to provide the necessary evidence to court, which will not constitute hearsay, because if it's hearsay, then it has to be corroborated. In this matter, what is clear is that the process leading to the termination of the Zimbabwean dispensation was or followed a process where the DG himself was actively involved by making the necessary submissions to the minister, but of course not prescribing to the minister what to do, simply making recommendations to the minister. So the DG is the person better positioned to provide the evidence as to the sequence of events and what triggered this entire process leading to the termination. And the minister's evidence, separate from that of the DG, becomes relevant if the minister has, over and above the submissions that he received from the DG, has himself then taken further decisions or altered the recommendations and made a different decision, then he has to justify. But if the minister finds that he was satisfied with the submissions from the DG and accept them and approve them, it is not necessary for the minister to be the one who narrate that through his mouth, because that must be narrated through the mouth of the DG, being the originator of the submission. So we submit that the affidavit of the minister was not necessary, nor can one say that the evidence that has been presented by the DG constituted inadmissible hearsay. So we submit that nothing turned on the absence of the confirmatory affidavit of the minister, because the minister, of course, is a functionary that has been cited as the one who took the decision, and the minister took that decision by accepting the recommendations of the DG. So we submit that the criticism on the absence of the affidavit is one that could be arrived at differently by the appeal court, which may accept that the evidence before court was sufficient to enable the court to make a determination on the evidence and not disregard it on the basis of the absence of the confirmatory affidavit of the minister. So lastly, then we deal with the court's remedy. On the remedy, the court has given remedy under section 172(1)(b) of the Constitution and section 8 of PAJA. We submit that either the court grants a remedial relief under 172 because it has found that the review was competent under the legality review under section 1C of the Constitution, or it has granted remedy under section 8 of PAJA because it has found that the review is competent under PAJA. So the court cannot do both because the two are mutually exclusive. So the court has both found that the remedial action is appropriate under section 172 and also appropriate under section 8 of PAJA. And we submit that the remedial action could only have been competent under section 172(1)(b) because the only competent review could have been one that is under the Constitution, which is legality. And the reason that we say so is because of the principle of subsidiarity. The principle of subsidiarity is that if there is legislation which gives effect to a constitutional right, one cannot rely directly on the Constitution, but one has to rely on that particular legislation. We know that Section 33 of the Constitution has given effect to by PAJA, and the PAJA is the one that remain the legislation that one can invoke if it is not a legislative act, and it can only be under Section 8 of that act, and not then under Section 172. So we submit that the remedial action that the court has made, and of course I'm alive to the fact that the only remedial action in the order itself is the one relating to what the court regards as the temporary relief, because the main one, the main relief is simply to declare the conduct unconstitutional, which that's what it did, and then from there, then it was remittal, which is the remedial action under that rubric of 172(1)(a), and so it then said that the matter should be remitted back to the minister for reconsideration in order for the minister to follow the procedure in Section 3 and 4 of PAJA. But of course, the minister cannot follow Section 3 and 4 of PAJA if the minister's decision is not one based on PAJA, or is not one that is affected by PAJA. And we submit that if, for instance, and we are confident that the appeal court would find that PAJA did not apply to this type of decision, then it would have been inappropriate for the court to prescribe even how the minister has to reconsider the matter, and that it must do it under Section and must follow the procedure in Section 3 and 4 of PAJA. So we submit that of course is another consideration that the appeal court will have to look at. Then when it comes to Section 8(1)(e), which the court said that it is entitled to grant temporary relief, of course temporary relief is granted under circumstances where the court has satisfied itself then on the evidence that there will be substantial harm that will be caused if a temporary relief is not granted. So it means that the papers themselves must still make out a case for an appropriate interdict with those requirements, four requirements present, like prima facie right, absence of alternative remedy, irreparable harm, and balance of convenience. So those factors must still be present in order for the court to invoke its powers under Section 8(1)(e) to grant a temporary relief. But in any event, that temporary relief was not necessary because we know that the minister had already taken a decision extending the grace period again until the 31st of December, and nothing really then prevents the minister from always then looking at the conditions prevalent at the time and to take a decision that does not adversely affect the ZEP members. So we submit that a leave to appeal should be granted to the Supreme Court of Appeal. This is quite an important matter, as we've said, and it involves the issues that the court has already highlighted in the judgment, which I've read the judgment. And we do not wish to refer the court again to the cases that we have relied on under the case that we've relied on in our aids of argument pertaining to the appropriate remedy. Those cases then are well known. They've been referred to by the court in the judgment, and we say that those cases actually support the applicant's contention instead of the contention that has been advanced by the court in the judgment. And so those would be our submissions, unless if there are other issues that the court would like to deal with. My junior justice alerted me to the issue of cost. Of course, when we say that this constitutional matter is a matter of public importance, the court ought to have applied the bio-wash principle so that then no adverse court order is made against the minister. And this is another order that the appeal court would come to a different conclusion, given that it seems to have been common cause between the parties that this matter does raise constitutional issues of tremendous importance. So those would be our submissions.
Thank you. Can I ask, Judge Malindi, do you have any questions?
Just one question. Thank you, my sister. Mr. Mukari, I'm just seeking a confirmation that the minister's extension from 30 June to the end of December, I think it is unaffected by the 12-month extension ordered by the court. Am I correct?
Yes, Justice Malindi, remember that the minister extended prior to the judgment of the court to 31 December, and that the judgment came and also said that the minister must do the process again, and gave the minister then 12 months and actually invoked Directive 1 of 2022 in the manner in which it protected the ZEP members. So yes, then it's correct that then it remains unaffected.
Thank you very much. Thank you, my sister.
Thank you, Judge Motha.
Yes, I have just one question. I'm not too sure if this was addressed because I got kicked out temporarily. I'm not sure, Mukari, how do you address the issue of the minister's conspicuous absence? He is conspicuous by his absence in this matter. We do not hear from the minister at all, and yet the minister is all over the news. We sure have heard the minister on TV in the extracts and reports, but we don't have an affidavit, let alone a confirmatory affidavit from the minister telling us his stance on this issue. So I'm not too sure if you've addressed that issue, but for me, that is paramount.
Yes, exactly. That's what you kicked out.
Yes.
I dealt with it, but let me just recap briefly on it. The minister is not conspicuously absent in these proceedings. He cited, and the DG has deposed to the affidavit, and that affidavit is deposed to as evidence that is relevant to the opposition by the minister. I dealt with the issue that the affidavit serves as evidence, and so the evidence of the DG was sufficient in order to deal with the processes that were followed in ensuring that the ZEP termination is done in the manner that it is done. So it was not necessary for the minister to depose to a confirmatory affidavit. So
but doesn't that amount to hearsay in as far as it relates to the minister?
No, it does not.
The minister is mentioned. And
no, it doesn't. It doesn't at all, because hearsay, hearsay operates in two ways. First, hearsay is not altogether inadmissible. What's admissible is a disputed hearsay. So hearsay which is not disputed then becomes evidence. For instance, if somebody has testified that so and so is a man, and then everybody accepts that is a man, you don't need to have that person to come and say.
But in this case, it was disputed, Mukari. Please, let's not play with words. There was a clear dispute here about what the minister intended to do. In fact, you are, I think, the second counsel of the minister. On the previous occasion, we heard that the decision had not been taken. Now we are told that the decision is taken. You really need to decide what you've done. That's why we want to hear from the minister and know what the minister's stance is all about here. We don't know. You are giving us this version. We had a different version. So when I ask you about a hearsay, you are giving me a sleight of hand, talking about Section 3 I'm very much aware of Section 3 that the court can pardon hearsay, but in this case, it's disputed. Now we have hearsay confronting this court. How do you deal with that?
Yes, I understand, Justice Muta, but as I've said, that is not hearsay at all. So we don't. So our submission is very clear that the DG has set out facts which are within his personal knowledge, and the minister's confirmation was not necessary. And also, I've heard that you said the minister is all over the news. Well, I don't watch news that much, so I'm not able to comment on that. I don't even know what he said in the news. But what I can talk about is what is in the papers. And what US justices can talk about is what is in the papers. Because I also assume you don't watch news every day. So you may have seen him on one occasion and you have missed him on other occasions where he said other things. So that's why things must be put on affidavit under oath, and then the court can deal with them.
Judge Mota, do you have any further questions?
It looks like it's frozen.
Yeah.
It looks like
The
it's
poll? Sorry,
yes.
Paul, are you there?
Yes,
Yeah,
ma'am.
just tell us what is the position with Judge Mota. His screen is frozen now.
Okay, just a moment.
Actually, it looks like he has been kicked out even.
No, he's no longer in the
Platform.
yes, but he's sent a request now, Judge. I'm admitting Judge Mota.
Okay.
Admitted Judge Kule.
Yes, he's back now. Sorry, Judge Mota, you got frozen and kicked out when I was being talked about it.
I don't know. Someone doesn't want me to hear these proceedings. But look, I won't take the matter any further. If you are of the view that it's not hearsay, we can leave it at that.
Well, thank you very much, Justice Mota.
Thank you, Mr. Mokari. Then is it Mr. Mojapelo?
Is the court, please?
Thank you, Mr. Mokari. Mr.
President.
Mojapelo, we're only going to give you until 11:05. You can confine your argument to that time, please.
Yeah, thank you for your generosity. We didn't plan to be more than 15 minutes.
That's fine. Thank you.
The issue that involves us is very crispy. It's only 7 pages of the judgment that deals with our issue.
Yeah.
My lady and justices, the importance or the test for leave to appeal is tried, and my learned colleague has touched on it extensively. I'm going to save time and not refer to it, although it appears in our heads of argument. We are of the view, and we make this submission, that this matter in general is a very important matter. This matter raises important issues of public interest, and the angle that the truck drivers have taken in this to challenge the decision and the legalities of the actions of the minister, we submit that it raises issues which another court, a higher court, might entertain. Without repeating the test, we will submit that we will try to convince you that at the end of our argument that you must formulate an opinion that the appeal would have prospects of success. Our issue is very crisp. Our application was dismissed purely based on PAJA, the requirement of 180 days, which is clearly visible from paragraph 18 of the judgment. And we submit that by crystallizing and characterizing our application as a PAJA, the court then applied the PAJA test, which we submit was a wrong test under the circumstances of the case. We state so because we submit that our case has always been based on the principles of legality, and I will refer the court to paragraph 3.3 up to 3.13 that deals with our quotations of the affidavits that clearly points to the fact that this application was never characterized as a PAJA application. So the 180 days submit in terms of PAJA, we submit with due respect that it is a wrong. And we proceed also by stating that our application was premised on 3 decisions. That is the 2017 ZEP decision, which will admit that there was a considerable time lapse between that time and the launch of the application. And the second decision was the December 2021 decision, that is the first extension, and the December 2022 extension. If I may just zoom on the last one, that is the December 2022, taking into account that this application, our application, the truck driver's application, was done in February 2023, even on the 180 days test, we submit that we would have succeeded. The court would have, even if it used that test, would still be obliged to deal with the merits because it was brought within 180 days. Although it is our main submission that this is not a PAJA case, this is not a PAJA test, it has always been a legality. On that basis alone, we submit with respect that this appeal has prospects, and a higher court might view this as an application of the wrong test, even if PAJA is applicable, that that the application was done within 180 days, therefore the merits should have been entertained. And on the issue of 2017 and 2021, where we clearly accept that there was a delay, we submit with respect that this court, in applying the legality review test, has the discretion either to overlook the delay, and of course that discretion is being triggered by the reasons and the circumstances of the case. In our papers, it is clear that when these initial decisions were made, especially the 2017 decision was made, the Drivers Association was not yet established. And there are other reasons that we submit that the court should have used to overlook the delay, and I'll refer the court from paragraph 3.20 of the heads of the arguments up to and the following paragraphs. The difficulty in making these submissions to court on this is that the court never went into the merits because the door was literally shut when we could not pass the 180 days test. In terms of paragraph 8 of the paragraph 18 of the judgment. So it is very difficult to find what would have been the hurdle that we needed to jump in order to deal with the delay. But as I stated, and I apologize for repeating, for the extension of December 2022, there is no issue.
For the legal representative, it doesn't matter who he is.
Who can you control the parties that are speaking out of turn, please? Either mute them or take them off the proceedings. It's interfering with the record.
Yes, I was just repeating that in any test, either legality delay or the PAJA delay on the last extension we are in, Therefore, the court should have entertained the merits. And then the last issue is the issue of cost. In paragraph 19, our application is dismissed with costs. And we submit, and the judgment is clear, even the submissions of the parties, no one will deviate from the fact that this application raises issues of important constitutional consideration. Of course, there's only one paragraph that deals with our costs. We do not know if there's any basis where the court has decided to deviate from the general principle. In BioWatch, although we accept that the cost issue is entirely the discretion of the court, but that discretion is to a large extent regulated and limited, especially in this type of matters, by the BioWatch principles. We do not have any explanation, any reasons why the court has decided to deviate from this principle. Of course, we are entitled to reasons, and we've stated that in our heads of arguments. Based on those submissions, we submit with respect that our application for leave to appeal passes the test, and we submit the court.
Sorry, Mr. Mojapelo. Depuo?
Sorry, Judge Kolisi, yes, I can hear you. I just wanted to alert the court. I had my mic on because Judge Mota was kicked out of the proceedings.
All right, but there are other people that are also talking, and it's causing a disturbance. Can you take these people off the proceedings, please?
Please don't take me out of the proceedings.
You will know who they are, because if it was within my, if I could do it, I would have kicked them out a long time ago. I'm not going to ask you again, please.
As the court pleases, I am at the conclusion of my short address, and I hope Judge Mota did not miss much.
I don't know where he lost you. Judge Mota, can you indicate?
Yes, I lost him on course.
Okay, we're still addressing that aspect.
Yes.
Maybe just repeat.
There's only one paragraph that deals with us on cost, which is paragraph 19. And of course, we do not have any reasons of the court for deviating from the BioWatch principle. We submit that in the judgment as a whole, and clearly identifies that this is a very important issue. The parties before this court will all accept that this case raises issues of constitutional importance, and our application is based on the challenge of the minister's statutory powers in terms of the Immigration Act. And we are a private citizen, and we submit with respect that on the issue of cost coupled with other issues, a higher court or this court should rule that our appeal has prospects of success. Alternatively, that there are compelling reasons why an appeal court should sit and listen to this matter. Unless there are questions from the bench, those are our submissions.
Judge Malinde?
Thank you very much, my sister. Mr. Mojapelo, condonation is granted at the discretion of the court. What are the prospects of succeeding on appeal in overturning the discretion exercised by this court?
Yes, my lord, if condonation is granted, especially for the 2017 decision and the 2021 decisions, we submit that the facts are very clear. It's a very crisp challenge of whether or not the minister had the power, firstly, to grant those dispensation, and secondly, to grant those extensions. Because even if we lose on whether the minister has got the power to grant those dispensation, that last one, the ZEP, the minister, the act is very silent on whether or not the minister has the power to extend those. And we submit that those are, if there is no statutory power given to the minister to extend, if there's no statutory power, as we've argued in the main, to grant this ZEP dispensation, then we have prospects of success on those. The difficulty with our case is that it was not considered because, according to the court, we failed the 180 days, so that the merits were never entertained.
Thank you, my sister.
Thank you. Judge Mota, are you still there?
Oh, it appears that Judge Mota has been kicked out again.
My lady, I'm just waiting for judge to send a request to be readmitted into the proceedings.
Yeah, there's a challenge now with his feet. Judge Mota?
He's there, my lady.
Yes, I can hear you. Maybe after this submission, can we take a break and get someone to assist me with my feeding?
Okay. Did you hear the question and the response, or did you just hear the part of it? Then it can be repeated for now.
Yeah, I just heard the part of the response.
All right. Perhaps, Mr. Majapelo, apologies. Can you just repeat your response to the question raised by Judge Malindi?
Okay. Thank you, my lady. Judge Malindi raised a question to me that even if condonation is granted, what are the chances that an appeal court would interfere with the discretion exercised by the court? And I summarized our case in the merits, which the cornerstone of our case is the statutory power that we submit that the Minister of Home Affairs does not have, never had to create the ZEP dispensation, that is the 2017 decision, and never, the Act is also silent on whether or not those dispensation can be extended. We are making a submission on the extension because even if we are wrong, even if it's found that we are wrong on the submission that the minister does not have a power to create the ZEP dispensation, the Act is silent on the power to extend those. So we submit that even if this court, the appeal court, would be inclined to interfere with the discretion of the court, this court, in our submission.
Okay. Thank you, Mr. Majapelo. Judge Mota, do you have any questions to pose to him?
No.
Okay, thank you, Mr. Majapelo. You kept to your time.
Thank you, my lady.
Thank you very much. So can we take a 10-minute adjournment or so, and then we'll reconvene at 11:05. And this is now with the arguments for the respondents.
Yes.
All right, thank you.
Thank you.